Videos of the street shows the agents catching up to him. Flores Ruiz runs across 10th Street while trying to get away, but the agents catch him and arrest him.
So in those circumstances, the appropriate vehicle for that evidence is the defendant can take the stand, okay? If you want those statements to come in, if you want to explain what you said to the cops, take the stand and explain it.
Yet there's so many people that criminally come here and use fraud or other fraudulent means to enjoy the American dream. It takes away from those individuals that really want to be here lawfully, right? So we do have to remove those elements out of here.
The backdoor judge, Judge Dugan, loses motions in limine. We've got a trial scheduled coming up very soon in December, and we're battling out over the trial rules. What evidence can be introduced, what experts can testify about what items, and so on. And Dugan, who you may recall, used the back door of her courtroom to escape this dude, Eduardo Flores Ruiz, as you recall, tried to help him avoid any arrest by ICE officials, is now in the thick of it. Trial starting soon. Remember this security camera footage explaining what happened?
He meets his attorney in the hallway and walks towards Circuit Court Judge Hannah Dugan's courtroom. Along the way, he passes plainclothes federal agents who are sitting on a bench. They are there to detain him. After Flores Ruiz walks by, the agents turn to each other and appear to confirm his identity amongst themselves. But a few moments later, Judge Dugan and another judge approach the agents sitting on the bench. A criminal complaint against Dugan later said she was alerted to their presence by a court official. That complaint says during this interaction, Dugan and the agents disagreed over the type of warrant they had to arrest Flores Ruiz. According to the complaint, Dugan ordered the agents to go to the chief judge's office. Video shows her pointing them through a double door. She then turns back to speak with other agents further down the hall and orders them through the doors as well. Shortly after that, with the agents gone from the hallway, Eduardo Flores Ruiz and his attorney exit into the hallway through a different door. As they walk down the hall toward the elevators, they pass another plainclothes federal agent. Neither they nor Judge Dugan seem to have noticed at the time. That agent motions to another to follow Flores Ruiz. Security video shows Flores Ruiz exiting through a basement exit. Upstairs on the 6th floor, the other agents have left the chief judge's office and worked their way downstairs. Flores Ruiz left the building onto 9th Street. Videos of the street shows the agents catching up to him. Flores Ruiz runs across 10th Street while trying to get away, but the agents catch him and arrest him.
And he has now been deported. So Flores Ruiz is afuera. Undocumented man, illegal alien, who by the way was a criminal defendant. He was in court for beating people. The victims that he beat were in the courtroom too, and she escaped him out of there because she would rather side with an illegal alien criminal defendant who allegedly beat the heck out of some people. That's why he was in court. So undocumented man, illegal alien, criminal defendant in a domestic violence case, tried to escape federal custody. And this is the pattern that exists, okay? If these judges and these courts would just detain them, oh, you got charged with a crime in the United States and you're here illegally, you're automatically a flight risk. You're automatically somebody who needs to be detained pending immigration services. You're not in our country legally. The courts should never have let them out. That's why ICE has to go get them. If they would just detain them and do what's called an ICE hold, then you wouldn't have to go through this process. But this judge, as we're going to see, tried everything she possibly could to prevent him from leaving because she's got a soft spot for illegal aliens, especially when they kind of look like her. Milwaukee County Circuit Judge Dugan, backdoor Dugan, was arrested in April and charged in a 2-count federal indictment, and now Ruiz is gone. They say after speaking to agents, she directed them to use her back door. He was arrested and charged and gone. ICE removed him a couple of weeks ago, and he's been in here twice. He's got a violent criminal history, including strangulation and suffocation, battery, and domestic abuse, this dude. And she's like, yeah, just use whatever door you want in my courtroom. Go wild. Trial is scheduled for December 15th. Motions have been flying back and forth. In federal court, Eastern District of Wisconsin, in the prosecution of the backdoor judge, Hannah C. Dugan, she is now facing 2 counts. 1 count of concealing a person from arrest and 1 count obstructing homeland security, saying the government, this is the judge writing, says that on April 18th, Dugan concealed an illegal using her backdoor. Case is scheduled for trial December 15th, just weeks away. Now, the government filed a consolidated motion in limine, saying we've got these 13 requests. When the trial starts, we'd like to have it go this way, as well as an additional motion to bar Doogie's expert testimony from coming in. So Doogie wants to bring in somebody to talk about the use of her backdoor, and the prosecutors, no, we don't want to hear about any of that. So the judge is going to say, let's talk about each one of these issues. Number one, first of all, the prosecutors are now moving to preclude the judge from mentioning potential punishment. That request is granted granted, that is a pretty standard request. You generally can't talk about the consequence, like you can't tell the jury, if you convict me, I'm going to prison for like 50 years. It has nothing to do with your innocence or guilt. That's a separate component of the trial. That's the penalty phase. So defendant doesn't object. DOJ just gets that in. Don't talk about it. We're just making that clear. She says, we weren't going to anyways. Okay. So request is granted. Don't talk about the consequences. Jury nullification. Another standard request you'll see in many of these. The government also says, do not try to nullify the jury. All right. Including saying, well, immigration policy, like maybe you love illegal aliens, or immigration enforcement. You can't talk about government misconduct like, face masks, like ICE agents are out there with face masks arresting people, kidnapping people off the street, like all of that stuff. Now, the defendant doesn't object to the government's request to prohibit her from arguing for jury nullification or appealing to jurors to decide the case on the basis of their personal views of immigration policy or enforcement. So we'll see how much tap dancing comes around, about that. Like even just saying ICE agents were in our courtroom, like that alone, you might say, well, just call them government agents or government officials, because ICE already has a negative connotation. So I'm sure we'll be battling about that. And we'll see how close Dugan's defense gets to that based on the makeup of the jury. They're going to try to get close to that. The government moves to bar discovery request or any commentary about discovery in the presence of the jury. Dugan says she is not opposed to the general idea of not arguing about discovery in front of the jury, saying, obviously, however, both parties will be commenting on discovery throughout the trial. For example, a question, answer, or comment during a trial that a document was produced by the government is proper and necessary. So with that understanding, the request is granted. So we're going to try to keep all discovery battles out of sight of the jury. Now, the government also moves to bar the defense, Doogie, from defining reasonable doubt. Now, the defendant does not object to that, but says, well, we can argue that the government hasn't carried its burden, and so their request is granted, right? So in other words, the judge can define the standard. The defense doesn't define the standard. Let the court do it. The defense says, of course, that's the court's job. Now, the government also moves to preclude Doogie from eliciting her own out-of-court statements. So she can't ask questions about things that she said outside of court because those would be self-serving hearsay, including self-serving statements that she made to police officers several days after the events at issue. She says, well, I want to call this cop to come in and testify, and I'm going to ask him about what Judge Dugan said. Objection, hearsay. The government says, no, those are out-of-court statements, and that's hearsay, and the rule of completeness would not require their admission. Now, Doogie says, I want those statements in. They're very good for me. She says that without additional context, it's difficult to respond on this point. She notes that out-of-court statements are not necessarily hearsay, and that statements offered for a relevant purpose other than the truth are not hearsay at all. The judge says, well, let me think about this. All right, so one of you wants to keep this out, the other wants to bring it in. Let's look at the law. Seventh Circuit has noted that defendants often try to justify their actions when talking to cops, and exculpatory statements don't have anything to do with the rule. So in those circumstances, the appropriate vehicle for that evidence is the defendant can take the stand. Okay, if you want those statements to come in, if you want to explain what you said to the cops, take the stand and explain it. Without knowing the precise statements that the defendant Doogie may want to introduce and why, I can't issue a definitive ruling now. But if you're going to introduce those statements, like if you're going to call a cop to the stand and say, what did Dugan tell you? You better explain a good reason for getting those statements in that are not hearsay, and then the judge will decide at the time. Now, what about the motives of law enforcement? Trump prosecutors want to stop any argument or questions about the motives of law enforcement. The defense team has claimed to reporters that this case was an attack on the judiciary, and this is politically charged. Trump is attacking the judges. The defense team also told reporters the government rushed to judgment in issuing the charges and then was stuck with going forward. The government says none of that is evidence that bears on the decision to prosecute. It's extraneous, it's collateral, and it should not be included at trial. Keep all of those length statements from Doogie's defense out. Now, Doogie objects to this request. She notes that the indictment alleges that agents plan to arrest this illegal in the hallway, but their plans apparently changed as they ended up arresting him outside the courthouse. Well, their plans changed because she diverted them and then let the illegal use the back door. But this defendant, Doogie says, this action, in other words, that they arrested him outside, says it puts the agent's intentions and motives at issue. She further says that the government made a rush charging decision, which required the agents to attempt to fit their investigation into a previous charging decision, says to the extent that the agents deny their plan changed, Dugan should be able to demonstrate and explain why they are motivated to change their stories. Now, the judge says, I'm interpreting this argument, and I don't understand Dugan to argue that she should be permitted to argue to the jury that the prosecution is politically motivated. Citing some other law, both sides will be allowed to present relevant evidence about what happened and why, and I guess they can talk about their motives, but I don't even even understand Dugan's real attack strategy here. The reason they arrested them outside the courthouse is because you escaped him from the building and diverted them, taking them into the judge's chambers to distract them from doing their jobs. Now, the indictment also says that Judge Dugan falsely told ICE agents that they needed a judicial warrant to arrest this illegal alien. A judicial warrant. You hear this talking point over and over. The government says she shouldn't even be able to talk about that, from arguing that a judicial warrant as opposed to an administrative warrant is needed to make an arrest in a public hallway. Now, the government says evidence will show that Dugan had reason to know that an administrative warrant was sufficient, right? The judge was just throwing her considerable weight around. I'm a judge. You know you need a judicial warrant for that. They said, no, we're ICE agents. We know we don't. We have an administrative warrant. It's right here. Get out of our faces. Now, Dugan objects. She says, I want to talk about this judicial warrant thing, noting the government made this an issue by alleging she committed obstruction by confronting members of ICE and falsely telling them that they needed a judicial warrant to effectuate the arrest. The indictment also alleges that Dugan knew a warrant had been issued. Evidence of what Dugan knew will overlap significantly with what was actually true. Now, Dugan does not actually present contrary authority on the issue of whether a judicial warrant was actually required here, but the indictment does make what defendant knew relevant. Both sides should be permitted to present evidence on that point. So we can talk about, probably will, the difference between judicial and administrative warrants in the trial, and we'll see how she explains that. Now, the government seeks to bar evidence or argument about her arrest or alluding to alternative means of bringing her to court, arguing that the only purpose would be to invite jurors to be mad at the government. She says, I want to talk about how I was arrested because it discredits the caliber of the investigation. Now, in the briefing on her motion to dismiss, even Dugan, in a footnote, they say, even Dugan says, assuming she said what the government claims about the judicial warrant, even they admit Dugan probably was wrong about whether ICE and an administrative warrant meets the Fourth Amendment muster, but it's not entirely settled. Dugan probably was wrong about whether ICE warrants are valid, but it's not entirely settled, right? So she's probably wrong. They're even admitting it. So defendant should be permitted to challenge the integrity of the investigation. However, it's unclear why this would include evidence about her arrest. It doesn't. Absent further explanation, the government's request will be granted. So they're just, well, she was arrested, she's a judge, and they were mean to her. Does that have any relevance to whether she escaped this illegal alien or not? No, it doesn't clearly. Now, the government moves to bar evidence or comment about the duration of the investigation. They say it has nothing to do with reasonable doubt. The government notes that members of the defense team have told the media this was a rush to judgment. The government says, no, it wasn't. The evidence will speak for itself. The jury will either agree or disagree about the guilt. Evidence or comments about the short interval, like they went real fast, it's not even relevant to the facts that are being presented. Now, Dugan objects. She says, I must be permitted to discredit the caliber of the investigation and the charging decision. She says the haste is relevant. It goes to bias. It goes to accuracy of fact-finding, the quality and the reliability of the investigation. The judge says, kind of difficult to rule on this one in the abstract. As indicated, defendant should be permitted to challenge the integrity of the investigation. However, I am disinclined, the judge says, to allow this trial to become a trial of the investigation. Under 403, rule we're very familiar with, which is if it's more probative, then it is prejudicial. If it's more helpful than it is harmful, we let it in. If it's more harmful than it is helpful, we keep it out. The court may exclude relevant evidence if its probative value is substantially outweighed by a danger of confusing the issues. If it misleads the jury, if it causes undue delay, or if it wastes time, we keep it out. So we'll have to figure that out at trial, and that will be coming soon. Now, the government also moves to bar any argument from Dugan that Dugan should not be convicted because she didn't succeed in preventing the arrest. Well, you got him anyways. You caught him outside. In other words, the defense may attempt to argue no harm, no foul. Such comment should be disallowed because neither of the statutes charged in the indictment requires that Dugan succeed in escaping in order to be convicted, or that law enforcement could have changed the location of the arrest. The government cites authority that neither of the charging statutes require success in the concealment of the person or in the obstruction of the proceedings. Now, she says, well, it does. She referred to her proposed jury instructions, including an element of materiality. Now, the government says that Dugan corruptly endeavored to obstruct this, to assist this guy to evade arrest in the hallway. She is going to argue she's not guilty. One reason she's not guilty, contrary to the indictment, is that at least by the time he emerged into the hallway, and maybe before, there was not a plan to arrest him in the hallway that she could have corruptly endeavored to obstruct. Now, the arguments that may be made to the jury will depend on our final instruction. Those are not finalized yet, and Doogie will be permitted to present evidence evidence and argument that she did not endeavor to obstruct the arrest of this illegal. Now, I will otherwise defer to the ruling on number 10 at this time and a couple more. We've got the government says we don't want evidence coming in of other ICE enforcement actions, saying you can bring it in to impeach a witness or show bias, but all of the other arrests don't have any relevance to this arrest. She says, I do. I want to explain how there were evolving policies set forth and it was impacting her thinking. Now, I agree with the defense that the evidence may be relevant to her mental state, and so she can talk about that. She can say they're arresting everybody, and so I was just trying to explain, come over here, and this is our new policy or whatever. The government also says that we want to keep out any evidence of her good motives, whatever those are, saying all of that will just mislead the jury. She says she does not know what evidence the government seeks to bar here. She intends to elicit evidence and make arguments about her state of mind. The government must prove she had corrupt motives and a corrupt intent. Her motives are relevant. So absent more specifics, I can't rule on this one either, and more. The government wants to get rid of her prior good acts, saying she might try to introduce evidence like she puts her shopping cart away, she opens the door for her mother. The government argues this evidence is inadmissible. You can't just bring in a bunch of like good character evidence. The defense says, I don't even know what you're talking about. We haven't even wanted to introduce any good acts evidence. And so the judge says, well, I'll just defer on this. If evidence pops up, we'll make a decision at trial. Similarly, prosecutors want to exclude expert testimony. They want to bring in an immigration lawyer about the meaning of certain statutory and regulatory terms. The government says the meaning of the term proceeding is a question of law. Okay, that's your decision, judge. You decide these definitions, not some other people come in and define what the law is. That's your job. Now, the Seventh Circuit, the judge writes, has consistently held that type of testimony can be excluded. The court was correct in noting that the meaning of words are for the judges, not for legal experts. The only legal expert in a federal courtroom is the judge. Dugan wants to come in and bring in this expert, this is the big one, saying we need this person to explain all this. She says we don't believe the government can factually satisfy the requirement, and so we need this testimony to come in and explain what the law is. But the judge says it is unclear how the proposed expert will provide evidence as to the facts. The government has indicated it will have ICE witnesses provide lay testimony describing where the issuance and the execution of the warrant was and how that fits into his overall immigration proceedings for this illegal. Judge says I will, at the final pretrial, we have another hearing coming up, discuss this with the parties, permissible defense testimony, including the proposed expert on this issue. And so sounds like that one may not be coming in, but we'll see. Now, in her first motion, Dugan also, so that was from the prosecutors. Now Dugan is responding, saying she wants an order that the government cannot rely on her lawful official acts to sustain the charges. She's renewing her immunity motion, which she already lost. In her second motion, she makes 12 additional requests. Number one, Dugan argues, she says lawful acts, if I can lawfully do it, that's not obstruction, saying the government cannot introduce any of those things, and the government may not contest that they were even official acts. She cites a couple cases, and the court cites those for us. She says she had a legal right to do everything she did. All 5 actions alleged in the indictment were within her authority to do so. So you can't use those against her, basically renewing judicial immunity. Now, as the government notes, her motion in limine would in effect confer partial judicial immunity. Judge says, I agree. The correct approach is to permit the jury to consider all of the conduct. Doogie loses again in deciding whether she concealed an alien or whether she corruptly endeavored to obstruct. The cases that she is relying on don't suggest differently. As the government notes, construing the term corruptly to require wrongful conduct, not immunity cases placing official judicial acts outside the scope of the statutes, is the interpretation. Now, the judge says, as I noted in denying her prior motion on this issue, there is no basis for granting immunity simply because some of the allegations in the indictment describe conduct that could be part of a judge's job. In the bribery cases, for example, judges who were convicted of bribery, they used judicial acts or tools to carry out their bribery. That doesn't mean they can't be prosecuted for bribery. So judge says, I'm not considering my previous ruling on the immunity issue. You've already lost that, and any official, unofficial distinction would be inconsistent with my prior ruling. Now, you're free to present evidence that you were doing your job, and the government will be allowed to say, well, that's not exactly your job, okay? Those are extraneous activities to your duties. You're exploiting your job in order to commit your obstruction, and so Dugan is denied. Another very big one on that one. So second motion says the defendant moves for sequestration, very standard defense request. All non-party witnesses need to be excluded from the courtroom. Government doesn't object. They don't care. As long as their case agent is there, pretty standard. In other words, you don't want witnesses to listen to other witnesses. Person A comes in, talks, person B sitting in the courtroom, person B comes up, just having listened to person A, testifies in conformity with their testimony, then you can't identify any irregularities between the two or any inconsistencies. So you preclude people, kick them out of the courtroom, they can't even listen to it, then bring them back in. Doogie also asks for jury instructions be provided in written form. Government says no problem, that's granted. Dugan moves to prohibit the government from introducing character evidence of other crimes. Government doesn't object, they say we're going to do that anyways, granted. Dugan moves to prohibit the government from introducing testimony that would create a mini trial. The government says we agree, we don't want a mini trial on these rules. However, how you handled Judge Dugan this illegals hearing and whether it was routine or business as usual is relevant to her intent. The government says that this illegal was charged with battery and his alleged victims were in the courtroom. Okay, the judge continued the case. The victims didn't even get to be heard or witness anything. She violated their rights as victims. How she handled this case off the record without notifying the victim or the prosecutor is all relevant. Whether the treatment of this victim was routine or an aberration is relevant to her state of mind. Does she always just ignore the victims who were sitting in her courtroom? Similarly, whether the treatment of these victims was consistent with the guidance she received is also likewise relevant to her intent. Marcy's Law, which is presumably some victims law in Wisconsin. Does she always just ignore victims who were seated in her courtroom while criminal defendants are getting shown the door? I will permit, writes this judge, the government to introduce evidence about whether Dugan handled this case in a customary fashion. This would seem relevant to her intent and to the position she has taken throughout these proceedings that all of the charged acts were done in the ordinary course of a judge's duties. She doesn't do this often or at all. However, I will exclude, pursuant to Rule 403, the balancing test, evidence or argument that Dugan violated victims' rights laws in Wisconsin. The probative value is substantially outweighed by a confusing of the issues, and it's just not relevant here. This is a federal case, not a state level Wisconsin case. And other cases say we can talk about training evidence and other things. Now, Dugan also moves to stop the government from talking about whether anyone personally believes she is guilty. The government says that's fine, okay, no problem, just as long as you don't do it. They say we won't. Dugan moves to prohibit the government from eliciting undisclosed expert testimony. Government doesn't oppose that, so that's granted. And Dugan wants to stop the government from eliciting expert testimony to talk about valid administrative warrants. The government says no expert opinion would be appropriate on whether it's valid. That's up to the judge. And the government does indicate that it will have witnesses from ICE who are going to come and testify about how they created the warrant and how the warrant fit in to his entire immigration proceeding. But the government is not calling any experts to explain what the law is, so that appears to be moot. Now, Dugan also moves to stop the government from using expert testimonies from the court procedures. The government says, well, any testimony from witnesses about court procedures will not be expert testimony that is outside the ability of jurors to comprehend at all. Rather, it's going to be factual observations. The government also says that such observations and perceptions are relevant to Dugan's intent in this case, given her filings and statements that she did nothing wrong. She's going to say it's business as usual. We want people in the court to explain why it's not business as usual. So as indicated, I'm going to give the prosecutors some leeway to demonstrate that this case was handled in an unusual fashion. It appears that evidence offered in the form of lay opinion, in other words, like a security guard says, yeah, this was weird. Everything was weird. As the government intends to call no expert witnesses, this also appears to be moot. Now, Dugan wants to introduce evidence from Pam Bondi and from Kash Patel. She says these statements are admissible because they're statements from a party opponent that show bias. The government says neither Bondi or Kash are going to testify. And so judge says without more, I agree with the government that Dugan should not be permitted to inject national political figures into this trial. Good call, judge. Any slight probative value of this evidence is outweighed by the danger of unfair prejudice. They want to come in here and scream about Kash and Pam the entire time. Make this case about Trump rather than the evidence. The judge is not allowing it. Good call. Now, Dugan moves for an order requiring the government to produce full transcripts and audio recordings. The government says, well, we're going to produce finalized versions soon anyways. And so the judge says, great, this should be moot. I'll address this at our final setting. Dugan also wants an order allowing her to introduce complete recordings. And the judge says, I'll make decisions at trial. She also wants, lastly, an order requiring the government to produce grand jury materials at least 2 weeks before trial. Government has no objection, therefore it is granted. And so, in conclusion, it is ordered that the government's consolidated motion is granted in part, and the government's motion to prohibit expert testimony also granted in part. So, a bunch of big wins for the prosecution here, signed by the district judge, Lynn Edelman. So, the big one, of course, is that she can't come in in here and bring in some expert to explain what the law is. The judge says, we're keeping that out. And other evidence can come in. And a lot of the bad stuff that she wanted to bring in is being kept out. So trial coming soon, December 15th, and we're getting the rules laid out. Jury selection will start and then will be underway. Now, this is acting ICE Director Todd Lyons saying here, we are removing illegal aliens from our country. It has to happen. And whether it's Trump ending TPS status for the Somalians or ICE officials arresting criminal illegal aliens outside of court hallways, they got to go. Here's Todd Lyons.
Hey, Rob. Good seeing you again. Thanks for having me. Yeah, so, ICE, obviously, we enforce the laws the way they're written, right? And so if someone's temporary protective status is lifted, which it's happened many a times to different various countries and nationalities, but we're ready to take action, and that's what we do, right? When someone's temporary protective status is lifted, they are now illegal aliens. They're here in the country illegally, and we will go ahead and remove those criminal elements out of our neighborhoods.
What was your reaction when you saw the details of the fraud inside of this community and just surreal what we've brought into our country?
One thing for me, Rob, is the fact that when you think about what TPS is actually created for, right, what the asylum process is created for, when you think about how many people take advantage of that, when there are so many individuals that want to come to the United States for a better life, yet there's so many people that criminally come here and use fraud or other fraudulent means to enjoy the American dream, it takes away from those individuals that really want to be here lawfully, right? So we do have to remove those elements out of here. And if temporary protective status is lifted for the Somali community, whether it's Minneapolis, could be Philadelphia, could be anywhere, we're going to go ahead and remove those elements out of our country, because at that point, especially the game here under false pretenses, that's what ICE does as a law enforcement mission. We have to ensure that we remove those people from our communities.
Yeah.
And even if you've got backdoor judges trying to escape them out their back doors, those ICE agents can run and they'll track them down right on the streets. And at least this guy is now gone. Undocumented illegal alien, arrested, deported, removed, and Dugan scheduled for trial for letting him use her back door. We'll keep our eye on this one, my friends. Thank you for subscribing and joining as we do.